Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2024-1372 DC, Zachary Conley versus Athena Couch. Today is Monday, November 25th, 2024 at 10:31 a.m.
Court will note the appearance of Mr. Kelly on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the defendant's motion. In this matter, it appears from the motion that it's for reconsideration. Ms. Couch, you can proceed with your motion.
Okay. I have filed this motion for reconsideration of the parenting time given to the plaintiff. I don't believe the current order is in the best interest of the minor children. Primary concern is money and control. In an effort to avoid paying child support, attorney Michael Kelly stated the plaintiff wanted primary custody of the children who have been under my supervision and care their entire life. It is apart from weekend visitation with grandparents. I wholeheartedly and unconditionally love my children, and I made it abundantly clear I did not want to put my children in daycare. I believe that having a positive parental figure is important for the development of children ages infant to preschool, to encourage an appropriate, safe, and consistent environment. I have stated in this motion how I aspire to feed the minor children healthy foods, more specifically nourishment for their bodies. Both of my children are in the 90th percentile for their height, and no one has mentioned how smart the children are. I, the defendant, have been reading books to the children since they were a week old, and we read books before bedtime and before nap time. They also know an abundance of nursery rhymes and songs. Excuse me. The minor children who are 2 years and 8 months old know the alphabet, numbers 1 through 15, all their shapes and colors. They also can say over 200 words, almost speak full sentences, and according to pbs.org, my children can read. Excuse me. You need to go play, please. I do think it's important to lead by example, and though my morals were in question due to lack of up-to-date tags on my vehicle, I am a good person. I opened doors for others, and most are greeted with a smile. I taught the minor children to say please, thank you, excuse me, and to cover their mouth when sneezing or coughing, and we do not judge others. If you are kind, kindness is reciprocated. I even, excuse me, you need to back up and go play. Excuse me. No. I'm sorry. No, you cannot be in here. You need to go play. I'm sorry. Honey, no. I'm sorry.
Anything else, Couch?
Yes, I'm sorry. I had lost my place. We do not judge others. And even then we do greet others with understanding. The plaintiff's character is in question, and I have asked the plaintiff for an explanation regarding him watching videos of children peeing in diapers, and even more so the videos of children and babies he was watching have enemas done to them, all of which he had no response or flat out lies. I can prove, I mean, I have evidence. I'm a mess. I apologize. If the plaintiff's family was also made aware of the plaintiff's sexual fetish of diapers, because quite frankly, it was appalling and I was concerned. Lori Putnam, the plaintiff's mother, stated on June 18th of 2022 that the plaintiff had started stealing his half-brother's diapers to use at 15, and that she consulted her husband and it wasn't an issue. She then consoled me and offered to give me a hug, and then proceeded to tell the plaintiff the next morning within earshot of where I was reading to the children that I, the defendant, was the problem. This is just one of the, stop please, stop. This is just one of the many instances that I have felt psychologically manipulated by the, stop please, stop honey, by the plaintiff's family. It is my belief that the plaintiff and his family's intent was to manipulate the court, and in altering information and therefore putting the plaintiff in a fatherly light. Unfortunately, this is contrary to what I have witnessed, and the plaintiff has had maniacal episodes where he would run through the house, shaking his head with his tongue out, and he would crawl across the floor. He has crawled across the floor of the minor children's bedroom, crouching and staring at me. As I stated in the motion, he frequently bangs his head into a steering wheel. And when asked why he was doing this, the plaintiff expressed to me that he has a hard head and that he used to bang his head into his school. Stop, please. Let me go play for a moment. I cannot. Okay.
Ma'am, the kids should not be hearing all this. You're going to have to remove them from the room, please.
I don't have another option.
You go into a different room. There's got to be another room you can go into to have this heard. If not another room, go outside or something.
Okay. Okay. I'm very sorry. I do apologize for being so all over the place. Okay. Plaintiff attended Lakeview schools, and it does surprise me that no administrative intervention was done with the plaintiff's parents. I do believe that plaintiff and his family are not positive, kind-hearted people who have the children's best interest in mind. On the contrary, malicious, manipulative, and falsifiers. I am here pleading you to take immediate notice of how the plaintiff's behavior is dangerous and potentially damaging to the minor children, Amelia Margaret Conley and Evelyn Ann Conley. It is imperative that the visitation between plaintiff and the minor children be supervised. Furthermore, no overnight visitations. And I am extending an alternative option for parenting time. Monday, 4 to 8 p.m., Wednesday, 4 to 8 p.m., and Saturday, 11 a.m. to 9 p.m. And that's everything.
Okay, anything else?
No.
Okay, Mr. Kelly, I have reviewed your answer.
Your Honor, then you're aware of the burden that must be carried. Palpable error has not been shown this morning, Your Honor. These are the same issues that have been brought up time and time again throughout this case. We had a hearing, evidence was presented, no palpable error has been shown this morning. Your Honor, we'd request the motion be denied. We'd also request attorney's fees for having to respond to this motion because it is not well based in law or fact, and is devoid of arguable legal merit. Thank you.
Thank you. Well, the court notes in reviewing all the pleadings and especially the defendant's motion that she does not allege or argue anything that was not previously addressed. There's no new information which would cause the court to change the order, and she has not established palpable error whereby the court was misled when the court made a ruling in this matter previously. As a result, the court will deny the motion. Mr. Kelly, you can do an order denying the motion submitted under 7-day. The court is not going to award any attorney fees at this time, but the court will consider that in the future in the event that the issues are in fact brought up again. So, Mr. Kelly, you can prepare the order, submit it, and that will conclude the case. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note that this matter is before the court on the defendant's emergency motion for an ex parte custody order in this matter. Ma'am, you've alleged a number of things as far as some pending parental kidnapping charges, et cetera, but you've not alleged what happened as a result of those charges. Have the charges concluded in any way?
I haven't heard anything, no.
Okay. Go ahead with your motion. Anything else?
This wasn't my motion, this was his motion.
Okay, I did say it was defendant's motion. I'm sorry, ma'am.
It's okay.
Mr. Miller, go ahead with your motion.
Okay, Your Honor, my name is Avery Miller Graham. I'm the father of Alea, Amira, and Akira Miller Graham, the minor children involved in this matter. I'm appearing before the court today in ex parte proceeding to seek immediate relief due to Miranda Finley violating the current parenting time order and engaging in abusive conduct towards our middle child, Amira Miller Graham. I respectfully request that the court issue temporary relief to protect the minor children's safety and to enforce my parenting time rights. The court has jurisdiction over this matter pursuant to MCL 722.27, which governs custody and parenting time in Michigan, and the venue is proper as Calhoun County is where the minor children reside. The parties were previously ordered to follow a parenting time schedule established by the court. However, Miranda has violated this order repeatedly by withholding my parenting time, thinking she is above the court, picking and choosing when I can see my children, and not allowing me to see my children on my weekends or any weekend at all. In addition to violation of the parenting time order, I have serious concerns regarding the safety and well-being of my daughters. Miranda Finley has engaged in abusive conduct towards Amira Miller Graham, including choking, fighting, bullying, taking verbal abuse, taking minor child's phone so she can't call for help. As a result of this abuse, my children do not wish to continue to live with Miranda Finley, are constantly depressed, scared, out of fear of Miss Finley. There's also an ongoing CPS case with Miranda. She hasn't been taking the youngest child, Akira Miller Graham, to school because Miranda was banned from Akira's school due to hysterical, vicious behavior on 4 separate occasions. I request for temporary relief from the court on an emergency basis in order to prevent further harm to the minor children and to enforce parenting time rights. An order requiring Miranda Finley to immediately comply with the parenting time schedule as set forth by the court, temporary custody of the minor child, or at a minimum supervised parenting time until further proceedings can be scheduled. An order directing Miranda Finley to immediately return the minor child's phone, as it is a reasonable expectation for the child to have access to communication with both parents. A temporary protection order to ensure the safety of the minor child if necessary. An order directing Child Protective Services to immediately investigate these allegations of abuse and file a report with the court.
Okay, anything else, sir?
No, that's it.
Okay, well, I will tell you, if CPS if there's a basis, they will investigate and then they will file a report at the conclusion, basically, of 30 days. So that's if they find that there's any basis for that. So I don't need to order them to do something that they're required to do in any event. What happens is the court will enforce the orders of the court. So if you're not getting parenting time, then the court will enforce that, and that parenting time will be ordered. If a party doesn't comply, they risk going to jail if they don't comply with parenting time. Ma'am, anything else you'd like to say before we conclude?
Yes, sir. So, Avery Miller has brainwashed my 14-year-old into believing that she's not safe. Her phone got took due to her failing grades, not because of her safety. I had recently moved back to Calhoun County, and my kids were going to Lakeview School, but I pulled them out of Lakeview School due to Avery going up there with CPS and acting like he was CPS and interrogating my 10-year-old daughter without my permission regarding that he has no parenting time, he's not on the birth certificate, and he's not on any paperwork. So I'm in the process of transferring their schools due to the safety of my concern for my kids, because he wasn't even supposed to know where my kids went to school at, because since he literally did this as soon as I moved back down here. He has not tried to get my kids since we went to court. He was able to talk to my girls on their own phones whenever he wanted to. He's been riding past my grandma's house harassing me. I just got this court order, so I haven't been able to go down to the courts to file a protection order against him because I have text messages and everything that I need to send to the court of him threatening me, him calling, like, it's always this. He's always threatening me. He's harassing me. I let him get his kids when he wants to. I let his family get the kids when they want to until it comes to this. He
Okay.
literally went to my daughter's school and interrogated her, and the school act thought that he worked with CPS. So I had an issue with the principal about it, and they put a no trespassing on me because I went up to the school because he pretended that he worked with CPS.
Okay, well, ma'am, you say that he has nothing in this matter that gives him any rights, but the court does note that there was an order for custody and parenting time back on March 22nd or 21st, 2022. So how are you saying that there's no paperwork
His parenting time was taken because of that.
taken?
Yes.
Your Honor, can I say something?
Go ahead, sir.
I never posed as a CPS worker. I had to meet the CPS worker Nikki Booker that was on the case. I had to meet her at the school because of several failed attempts to meet with Miranda to interrogate, as she calls it, the kids, the minor children. She was dodging Nikki Booker, so I said that I would meet her at the school. Nikki showed them her credentials and everything. I can't pose as a CPS worker and not show them any credentials, and they let me talk to a minor child.
Okay.
And she's right as far as that goes. Like, I'm not able to get any records from the school because the records would indicate that Akira has only been in school maybe 2 weeks, and the school year started months ago.
Because she was going to Lansing school before we moved down here.
Okay, let me see.
Can I say something else as well before you're done?
Just a minute, ma'am.
I don't understand why we got to keep going through this and our kids.
Ma'am, just a minute. Okay, I wanted to get back to the order, so I'm pulling the order up. Okay, this is the order that was dated March 21, 2022. It did provide for a suspension of parenting time pending those parental kidnapping charges. And you're saying they haven't been resolved at this point?
No.
Your Honor, they have been resolved. They lessened the charge because it was never me just like taking or kidnapping the kids. It was me not sending them back to the mom on as the court order stated. I was supposed to send them back, and I never sent them back. So that was violating the court order, and it started out a parental kidnapping, but they lessened the charge, and I ended up getting probation and did probation for it.
Okay. Well,
in Kalamazoo County.
What you're going to have to do, sir, is that order is still in place until it's changed. So as it relates to parenting time, you're going to have to file a motion for parenting time in this matter, and you're going to have to set forth the basis for doing it. And then the court will entertain it at that point, but this is a different motion. You're seeking a motion for ex parte custody. Custody is different than parenting time. Anything else, ma'am, before we conclude?
Yes, two things. The CPS case was closed due to no findings, and I wasn't dodging the CPS worker. I got in touch with her, and I also have text messages proving that I was trying to get in touch with her several times, and she canceled on me several times.
Okay. Well, what the court notes in this matter is that the defendant does file the motion in very conclusory terms. There's no allegations of fact on which the court can determine if there is in fact probable cause or change in circumstances sufficient to modify custody. And the request is for modification of custody. And as a result, There's no basis for the court to do that, so I'm going to deny the motion at this time. Ma'am, you're going to have to prepare an order denying the motion. And otherwise, sir, if you wish to have parenting time, you'll have to file a motion for that and set forth facts on which the court should base the finding. So court will conclude this matter. You're free to go. Have a good day.
Thank you.
Thank you.